You are told this is about immigration. You are told this is about national security. You are told this is about a fluid situation in a foreign country. But that is not the story. The real story is this. 137 human beings were removed from the protection of the U.S. Constitution. No trial, no hearing, no judge. They were put on planes, flown out of U.S. jurisdiction, and dropped into a legal black hole. I've spent my life studying how systems fail. And I can tell you this clearly, when due process disappears for some, it never stays there. If the government can pause the law once, it can do it again. And next time, the category may be wider, closer, uncomfortably familiar. Stay with me, because what you're about to see is not chaos. It's design. And to understand how we arrived here, we need to step back and look at the system that made this possible. This is not a story about whether those 137 people are guilty or innocent. That question was never asked. This is a story about who decides when the law applies. In the United States, the Constitution is not optional. It does not pause during elections. It does not disappear when planes leave the runway. And it does not stop at the border. Yet what we are witnessing is an argument from power, not from law. An argument that says, because the situation is complicated, the rules can wait. That logic is dangerous, because once you accept it, there is no limiting principle. No clear line, no moment where the exception ends. The fight in this case is not procedural. It is existential. It asks whether courts still matter when the executive decides speed is more important than rights. And to understand how we reached a point where that question is even on the table, we have to look backward at the legal and historical tools that were quietly pulled off the shelf. Every constitutional breakdown has a history. And this one did not begin on a runway. It began with a law written for war, not for courts. A statute designed for moments when nations face enemies, not migrants seeking refuge. Over time, that law sat quietly in the background, rarely used, rarely questioned. But history teaches us something uncomfortable. Old emergency powers never disappear. They wait. They wait for fear. They wait for political pressure. They wait for a moment when speed is valued more than scrutiny. When that moment arrives, the language changes. Rights become technicalities. Judges become obstacles. And legality becomes a problem to manage, not a principle to obey. This is how extraordinary powers slide into ordinary governance. Not with a declaration, but with repetition. Once the precedent is set, it no longer feels radical. It feels routine. And that is why the next moment in this story matters so much. Because when the courts tried to stop it, the response was not compliance. It was acceleration. The first real rupture came when the courts intervened. A federal judge did what judges are supposed to do. He asserted jurisdiction. He ordered the planes grounded. He said, stop. And the response was not confusion. It was defiance. Flights continued. People were moved faster. Jurisdiction was outrun literally by altitude and speed. In legal terms, there is a word for this. Contempt, not disagreement, not appeal. Contempt. The message was unmistakable. By the time the law catches up, the facts on the ground will already be irreversible. This is a classic crisis tactic. Move first, justify later. Dare the system to respond. And when whistleblowers revealed that court orders were treated as suggestions, not commands, the damage was already done. Those planes had landed. Those people were gone. If you believe courts still matter, this is the moment that should trouble you. Because once court orders can be ignored without consequence, the rule of law becomes performative. And what followed next showed just how far this logic was willing to go. Beyond borders, beyond jurisdiction, and into something far more dangerous. What looks chaotic here is anything but. There is a pattern I've seen repeatedly across governments and decades. Create a problem, externalize it, then claim the solution is impossible because the situation is fluid by removing these detainees from U.S. soil. The executive didn't just move people. It moved responsibility out of sight, out of reach, out of time. This is how accountability is dissolved without ever being formally denied. Courts are told, we intend to comply. But compliance is always postponed until tomorrow, until next week, until conditions stabilize. And conditions, conveniently, never stabilize. Foreign territory becomes a legal fog. Emergency becomes a permanent excuse. And delay becomes policy. The brilliance and danger of this mechanism is that it sounds reasonable, measured, pragmatic, but it achieves something radical. It turns constitutional rights into logistical problems. And once rights are framed as logistics, they can be managed, deferred, or quietly abandoned. This is why the next escalation mattered so deeply. Because when the system was challenged again, it didn't retreat. It widened the battlefield. The second rupture came wrapped in geopolitics. Suddenly, the story was no longer about court orders. It was about Venezuela, about instability, about a situation that had changed dramatically. That phrase did a lot of work, because instead of answering the judge's question, how will you restore due process, the government reframed the problem. They said the ground had shifted, that control was uncertain, that time was needed. Time for what? To decide whether the Constitution still applied. This is where the escalation became unmistakable. A foreign crisis was not just a backdrop. It became the argument. The implication was chilling. Because we helped create this instability, we are now excused from fixing the harm it caused. Power created the emergency, then cited the emergency to avoid accountability. This is not a failure of planning. It is a strategy of insulation. And once the court granted even a short extension, the signal was clear. Delay was working. But behind every motion and deadline were real people. People whose lives were being measured in days, not legal briefs. And that is where the story turns from abstract law to human consequence. Now, put yourself where the law no longer reaches. You don't know the charges. You don't see a lawyer. You don't stand before a judge. You are moved between countries as paperwork. Your fate debated in filings you will never read. For the 137 people at the center of this case, time is not abstract. It is measured in fear, in isolation, in the silence that comes when no court date exists. And here is the truth that should unsettle you. Due process is not about sympathy. It is about protection. It exists precisely for moments when the government insists it cannot wait. When urgency becomes the excuse, when power demands speed, if the law can be suspended for them, it can be suspended for anyone the system finds inconvenient. That is not speculation. That is history. If this matters to you, if you believe rights only mean something when they are enforced, then don't look away now. Stay with me. Because what happens next does not stop at borders. It reshapes how power moves across the world. When the United States bends its own legal commitments, the consequences do not stay domestic. Other governments are watching. Not the speeches, but the behavior. If due process can be paused here, it becomes easier to pause elsewhere. If courts can be sidelined in Washington, they can be sidelined in Ankara, Budapest, or Caracas. This is how norms erode not through open rejection, but through selective application. There is also a second signal being sent that power, not law, defines legitimacy. That control of territory and resources can justify extraordinary measures. We have seen this logic before. It does not produce stability. It produces imitation, and once imitation begins, restraint disappears. Human rights stop being universal. They become conditional, granted to allies, denied to adversaries, suspended when inconvenient. That is why this case matters beyond 137 individuals. It is about whether the rule-based order is real or rhetorical. Because if the strongest democracy treats law as optional under pressure, others will follow, with fewer safeguards, less scrutiny, and far harsher outcomes. And that leaves us facing a question the world has confronted before. What happens next when the system refuses to correct itself? From here, the future splits into three paths. The first is correction. The courts reassert authority. Deadlines are enforced. The government is compelled to act, not explain. Due process is restored not because it is convenient, but because the system still works when pushed hard enough. That outcome would matter far beyond this case. It would signal that emergency cannot permanently outrun law. The second path is normalization. Extensions become routine. Compliance becomes symbolic. The case drags on while lives remain suspended in limbo. Nothing dramatic happens. And that is the danger. Because once delay feels normal, abuse no longer shocks. It blends into the background of governance. The third path is rupture. Open defiance. Orders ignored. Power daring the judiciary to respond and betting it won't. History is unambiguous about where that path leads. When courts lose relevance, constitutions become decoration. Which path we take will not be decided by rhetoric. It will be decided by enforcement. And that brings us to the final question. What this moment reveals about who we are and what we are willing to tolerate when power is tested. Moments like this are easy to miss. They don't arrive with tanks in the streets or speeches declaring emergency rule. They arrive as motions for extensions, as language about logistics, as assurances that the system is working. But the measure of a democracy is not how it behaves when it is comfortable. It is how it behaves when power is impatient. If courts matter only when they are obeyed voluntarily, they do not matter at all. If rights exist only when they are convenient, they are privileges, not protections. What is happening here is not about left or right. It is about whether law still sets the boundaries of power or whether power now decides when law applies. You don't need to agree on policy to see the danger. You only need to ask one question. What happens when this logic is used against someone you recognize? If this analysis helped you see the system more clearly, share it. These conversations only matter if they spread. And stay with me, because this case is not the end of the story. It is the signal for what comes next.